Learned counsel, appearing on behalf of the respondents, vehemently argued that the jurisdiction under section 4975 CRPC cannot be enlarged to the extent of cancellation of bail by the court suo moto, and that powers under section 4975 CRPC can only be exercised on an application either moved by the complainant of the case or by the state. Full stop. He submitted that the bail allowed by the subordinate courts in the discretionary jurisdiction is not normally interfered by the superior courts unless it is misused or grant of bail has caused miscarriage of justice. Full stop. Learned counsel argued that in a similar case the apex court allowed bail to the accused who were only attributed the role of raising lalkara in a murder case within 2 months from the date of refusal of bail by the High Court. Full stop. Learned counsel, on the strength of case law, further argued that notwithstanding the prohibition contained in subsection 1 of section 497 CRPC, the court on any valid ground can grant bail to an accused who is involved in a case punishable with death or imprisonment for life or imprisonment for 10 years, and that in the present case there were sufficient grounds to believe that the respondents have not committed such an offence. Full stop. The learned counsel, while summing up, argued that the learned additional session judge has neither exceeded his jurisdiction nor exercised the discretion in an improper manner, and further there was also no allegation of misuse of concession of bail by the respondents. Therefore, the bail allowed to the respondents by the learned additional session judge is not liable to be interfered by this court at this stage in exercise of suo moto powers under section 4975 CRPC. Full stop. The main thrust of the learned counsel was that in the initial investigation conducted by a sub-inspector, the present respondents were found not present at the spot at the time of occurrence. Therefore, they richly deserved to the concession of bail. Full stop. Learned counsel representing the complainant while supporting the cancellation of bail has argued that the respondents were not only attributed the role of lalkara but they, with the demand of possession of land from the complainant and his deceased father, extended threats of life to them at their dera shortly before the fateful occurrence, and then while forming an unlawful assembly and actively participating in the occurrence, instigated their co-accused, who were armed with deadly weapons, to teach a lesson to the complainant and his father for cultivating the land without their permission. Full stop. He added that in consequence to the aggression of the respondents, Munir Ahmed lost his life in the occurrence. Therefore, the mere fact that the respondents were empty-handed and raised only lalkara would not be valid ground to extend them concession of bail in a case of capital punishment. Full stop. At such an early stage, when the investigation was still at initial stage, full stop.